Well, the next case is Leaffilter North LLC versus Dunphy et al. Each part will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
3 minutes, Your Honor.
3 minutes, very good. I'll make note of that. You can see on your left there is that clock. Please look at the top one. If you're looking at it, that is your time. I'll try to let you know when you get like a minute left in your initial time.
Great.
For the 3 minutes, I'm not going to interrupt your time for that.
Thank you.
Counsel, I'll try to let you know about a minute left in your time as well before I do the argument. And if you're in the middle clock there, please disregard the lower clock. We're not going to use that for your argument today, so don't worry about that. The argument will be being recorded, so when you come up, please introduce yourself. Please stay behind the podium and speak loudly, both visually and audio recording. I don't think it matters in this case, but if you had a child, a minor, a victim, please use the initials for them rather than their full name. I don't think that's going to apply either. We read your brief and are ready to proceed whenever you are.
Thank you, Your Honor. May it please the court. My name is Barrett Bulbert on behalf of appellants Timothy Dunphy and Home Genius. There are two assignments of error before the court today. First, the district court erred by overruling appellant's objection to the magistrate's decision's findings of facts, where those findings were based solely on unverified allegations in the complaint. Second, the district court erred by overruling appellant's objection to the magistrate's decision's conclusion of the law, determining that an arbitration provision that permitted Appellee Leaffilter to choose whether to go to arbitration or court, but did not before Dunphy that same choice, was enforceable. I will address each in turn. First, with respect to the findings of fact, which are reviewed for abuse of discretion. The magistrate's decision on a motion to compel arbitration contained wide-ranging findings of facts that essentially regurgitated the unverified allegations of the complaint. And to be clear, these findings of fact were on important issues, such as the nature of both Leaffilter's and Home Genius's businesses, such as whether they are competitors, what steps Leaffilter took to protect its confidential information in a trade secrets case, and Mr. Dunphy's actions when departing Leaffilter.
Did the judge rely upon those facts in her determination on the objections?
Interestingly, the judge barely mentioned anything about the findings of fact. All he said was that he reached its decision to adopt the magistrate's decision in whole solely on the language in the agreement and not based on unsworn allegations of the complaint. And the problem here, we assert, is that the trial court's order should have just gone a step further and stricken those findings of fact that are, again, completely unsupported by the evidence. The fact that the district court did not take that extra step, we view as an error. In fact, arguably...
What is the prejudice from that error? Let's say you're right in that error. How is your client harmed?
Sure. Understand that's an argument Leaffilter makes, is that it's all harmless. And our contention is that there is still the prospect for substantial injustice here, because these findings of facts are based on key issues in the underlying dispute, which involves a non-competition agreement and trade secret claims, that those findings of facts could be viewed as preclusive, or even if not preclusive, persuasive, i.e., well, previously this court has determined that Home Genius and Leaffilter are competitors. That could be an argument presented on the basis of the magistrate judge's decision. And we do view that as presenting the prospect for injustice, and that such error is not harmless.
So you would have to be arguing that we would go beyond what the judge has said and go behind her statement that she's not considering all that she's not considering any unsupported facts, and we'd have to basically assume that she is incorrect and was dishonest, and she did in fact consider it for there to be prejudice.
I don't believe that's the case, Your Honor. All that this court needs to do is issue an order requiring the district court to strike the findings of facts of the magistrate judge's decision.
But the point is, even if you strike something, it's just like we say in front of a jury, they can still consider it. They just don't tell you they're considering it. So to me, that's what you're asking us to do. You're asking us to say we don't believe the judge.
Understand your point, Your Honor. I do think, though, that while we all recognize that with jurors, a motion to strike may not really have any practical effect, there is still, from our point of view, the value in being able to respond to that argument by saying, oh, no, those findings of fact, which rely solely on unverified allegations, were stricken. So we view this as really a simple matter and a simple fix that can prevent any prospect for injustice. I'll move on, however, to assignment of error number 2. This is with respect to the conclusions of law, which are reviewed de novo. At issue in this motion to call arbitration is an arbitration agreement that was imposed on Mr. Tim Dunphy as a condition of employment. And it permits the Leaffilter to pick and choose between arbitration and court when it brings claims, while it requires Mr. Dunphy to bring all of his claims in arbitration.
Well, just claims for injunction on Leaffilter. If they had some other cause of action, they would have had to go through arbitration. It's just injunction, those types of claims. Or perhaps other one, but specifically injunction was excluded.
That's actually not what the language says, Your Honor. The carve-out here is except that should an injunction and or other equitable relief be sought by Leaffilter, such injunction and any other claims related to employment of the employee may be sought at Leaffilter's discretion in either state or federal court in Summit County, Ohio. So essentially, all that Leaffilter needs to do is add one single claim for equitable relief. It doesn't need to be injunctive relief, but one claim based in equity, and they can have their entire lawsuit proceed in court rather than arbitration. But Mr. Dunphy wanted to bring a declaratory judgment action asserting that his covenants are unenforceable. They're overbroad. He has to do that in arbitration, and that just isn't fair from our perspective. And that's supported by the majority of the case law, which we've identified in our briefs, and I'm happy to go through here today. Chief among them is the Post v. ProCare Automotive Service Solutions case. There, that arbitration agreement was actually narrower. It required the employee to arbitrate all disputes related to the employment agreement, but only allowed the employer the ability to go into court to obtain injunctive relief for a breach of restrictive covenant. So it was narrow. It didn't include equitable relief of any sort. It didn't then also allow tag on for any other claims related to the employment. And the 8th District found that this provision, which allowed the employer to use a judicial forum when it's the plaintiff, but limited the employee to arbitration when it's the plaintiff, was unconscionable. Now, I understand Leaffilter's argument is that this is dicta, and I've read this decision probably 100 times, and I certainly do not believe that that's the case. There were 2 rationales used by the Post Court to determine that the arbitration agreement was unconscionable. The dicta in that decision related to a cost-splitting provision, where the court determined, well, there really wasn't evidence on whether cost splitting was a burden, and we don't need to decide that issue. So I think Post v. ProCare is directly on point, and it's followed by the other decision cited in our brief, Arnold v. Burger King, Cleveland v. Power Home Solar. I would like to briefly address the Qualls v. Wright Pat Credit Union case, which, as I read Leaffilter's papers, it is their main case that they rely on in opposition to the proposition that this agreement is substantively unconscionable. It's a unilateral discretionary exception. Leaffilter says in its brief, Qualls held that merely because the employer need not arbitrate a claim for injunctive relief or equitable relief involving trade secrets or competition does not make the arbitration agreement unreasonable. Now, first, this quotation that Leaffilter relies on repeatedly, that actually came from the concurring and dissenting opinion in the Post case. And it was a quotation of another opinion, not a holding. And that concurring and dissenting opinion in Post said, well, I don't think that this is unconscionable because an employee who is at will has the right to choose to work for the employer or not. They don't have to agree to the agreement. And as we've explained in our paper, and as I'll touch on later with respect to procedural unconscionability, that is not a hard and fast rule.
Let's take a step back. The trial court didn't reach unconscionability.
Sure.
The trial court, based upon the contract here, said we just can't rule in your client's favor based upon the contract, and never got it unconscionability. So why is the trial court wrong on its legal finding about the terms of the contract?
Sure. The trial court was wrong on severability because the agreement here includes a broad severability clause that makes clear the party's intent that should any provision be found unenforceable, it be excised. Now, what the trial court's order did is it said, well, let's assume it's unconscionable or not. I don't even need to decide that. It's not severable because there are other provisions in the contract that led the trial court to believe that the intent of the parties would be destroyed if this unilateral discretionary exception was excised. And our answer is that that is not what is clear from the contract. And following the Ignacio case from the Supreme Court, the Supreme Court relied upon a broad severability clause to determine that a provision that basically gave the broader appellate review for an arbitration decision that permitted under the Ohio Arbitration Act could be excised. And just as in Ignacio, we have that severability language here. Additionally, the three other provisions that are pointed to by the trial court in Leaffilter. First, there's a provision on governing law and venue. And that governing law and venue clause provides for jurisdiction and venue in Summit County, Ohio, for any action to enforce an arbitration award, any action by Leaffilter for specific performance, injunctive relief, and any other matter not subject to arbitration. And so, from our point of view, right, the jurisdiction venue clause is still valid because if you need to go enforce an arbitration award, you go to court to do it. And this clause is providing where you go do it.
And you're down to about a minute in your time. The trial court relied upon counsel small enterprise to say that you can't force a party to arbitration on something they didn't contract. And Leaffilter said we didn't contract injunctions and equitable relief. Why is that wrong? Why is this something that the court, they should be required to do, arbitration, Leaffilter?
Sure, because everything else about this arbitration agreement suggests mutuality, right? It's even titled a confidentiality, non-competition, and arbitration agreement. It's not titled confidentiality, non-competition, and arbitration except in certain few instances agreement, right? Basically, if we take the proposition that an agreement with an unconscionable term can never be severed, then the Ignacio decision basically is overruled, right? In Ignacio, the court made the same point. Just because by excising that arbitration carve out for broader review of an arbitration award, that didn't change the character of the agreement. And here, we have an arbitration agreement. Making everybody arbitrate doesn't change that character.
If you want to stop or continue, it's up to you. But you're in.
Yes. Thank you, Your Honor. I will reserve the rest of my time.
Thank you.
May it please the court, my name is Joe Gross. I represent Leaffilter North LLC. Appellants have two assignments of errors we just found out. The first is that the trial court erred in overruling appellant's objections to the magistrate's findings of fact when those findings were based on an unverified complaint. And the second was that the trial court erred by overruling appellant's objections to the magistrate's conclusion of law that the arbitration provision was unenforceable as written, because Leaffilter could take its request for injunctive relief to court. Before I address those assignments of error in particular, I want to point out, as Judge Stevenson brought up, that the trial court appropriately considered the magistrate's decision, did its own independent analysis of Mr. Dunphy's agreement, and found that without regard to any unverified allegations in the complaint, and without regard to procedural or substantive unconscionability, Mr. Dunphy and Leaffilter never agreed that Leaffilter would take all of its disputes to arbitration, and the parties had carved out of the arbitration agreement any disputes in which Leaffilter sought injunctive relief. That was the contract. That's what both parties signed. Nothing in the law requires arbitration agreements not to have subject matter carve-outs. It's like any other contract. And there doesn't have to be a separate agreement to take a breach of contract action requiring injunctive relief, in our case, to court. So we didn't have to have special language to go to court. It's what any party can do. I would add that the case that appellants rely on, Post versus Procare, had the same type of carve-out. And unlike the dicta in that case, Judge Cooney in the dissent pointed out that, and it was actually in the opinion itself, that Procare, before this case had been filed by the plaintiffs, Procare had taken Anderson to court on trying to get a preliminary injunction on a non-compete matter. So despite the dicta, because Procare had really focused on the attorney's fees being able to be recovered if there was punitive damages, and somewhat on the cost-splitting argument, it made comments about that which Judge Cooney and then Qualls later on directly addressed.
How is the trial court cited Ignacio for their decision? And Ignacio seemed to me to have a case where there was an arbitration agreement and the court severed some of it and said to arbitrate. How is it different than this case where they're asking for the same thing? Cut out a portion, but you folks agreed to arbitrate. You're just arbitrating. That's not anything different than what you agreed to.
Ignacio is way different. First off, it struck a whole sentence, a whole provision of that. And it had nothing to do with the arbitration itself. It had to do with the jurisdiction that a court of common pleas has when enforcing an arbitration award or looking to vacate or modify it. It says a trial court doesn't have that within its jurisdiction.
So that's certainly one. Are you saying that was a separate provision of Ignacio? This appellate right of Ignacio was different than the general other provision?
Yes, I think it's an important difference, Your Honor. In our case, the appellants are asking for the trial court, and you now, to take a part of a sentence after a comma and strike it out and leave the rest. In that case, the Supreme Court found that the intent of the parties was to have arbitration, and that I don't want to call it an appeal because it's not an appeal, but the court part of enforcing or modifying the arbitration award was unlawful. The Ohio Arbitration Act doesn't give the court the power to do that, and struck it, thinking that the intent of the parties was still to have arbitration. And that's not the case here. The trial court properly found that the parties never agreed to arbitrate everything. So that's the important difference there.
Are there items your client would have had to arbitrate if they wanted to bring certain cause of action?
Yeah.
Injunctions and equitable relief, no, but other cause of action?
Like if the person converted some money, so that they would have to go to court to deal with that. Or if I have some cases, just recently had one on a faithless servant doctrine, so that the person didn't, intentionally screwed something up at work that person warranted to the employer that wouldn't do. That would go to court or would go to arbitration. They would have to file an arbitration demand and do all the things. So not everything would have to go. It would require injunctive relief, and nothing more could have warranted injunctive relief than what was in the complaint when Mr. Dunphy was alleged to have taken lots of confidential information just before going to a competitor. So,
Counsel, what about the argument they're making that it's overly broad in regard to, and therefore makes it basically unconscionable? It could have been just, that the parties agree that injunction-related relief pertaining to a covenant not to compete, you know, that is not subject to arbitration. But this is a lot broader than that.
It's a little broader than that because when the injunctive relief, which is asked for in a breach of contract claim like ours was, there's damages at the end of the day. So if you're going through we didn't have a temporary restraining order, but we had a motion for preliminary injunction pending. And when you go through and do all the facts discovery that you need to do in coming up with trying to get to a preliminary injunction, then the next step is to get the permanent injunction. So it's not over when you get the motion for preliminary injunction because you still have to have a trial on the permanent injunction and the damages associated with what happened. So
I understand that. I guess what I'm wondering is, though, because it seems to me that the whole point of this in regard to an employer-employee situation where, you know, obviously they're privy to client lists, they're privy to confidential information and so forth, is to prevent them from going to work and using that against the employer. Okay. So arbitration can, you know, it can resolve anything. You know, the case law talks about how you can take anything to arbitration. However, if you need immediate relief, it seems like it's reasonable for an employer to put in there, in regard to a covenant not to compete, the ability to go to court for immediate relief to stop that from happening, which you're not going to be able to get ordinarily, or I don't think you're going to be able to get, period, from an arbitration. But again, what's to prevent you from getting the immediate relief, getting the preliminary injunction, and then going to arbitration?
the parties could have agreed to that, but they didn't.
Right, so they're saying it's unconscionable.
They're saying that's unconscionable because the parties agreed that that one party would be able to take its request for immediate relief and get everything associated with that into court. Well, I disagree. Qualls and Robbins versus Country Club Retirement Center directly addresses that point, Your Honor, and we mentioned that in our briefs. And let me, I've got 6 minutes left. So I hope I answered your question.
The trial court here, I mean, and certainly to me, in essence, said under Ignacio and the other cases, this contract is such that the contract does not require arbitration for injunctions, which I appreciate. But should the court still have ruled on unconscionability and decided some factors regarding that? Just because a contract's good doesn't mean it can't be unconscionable, that there could have been some problems in the negotiation and all those types of things.
Well, I'll answer that in 2 steps. First off, on the conscionability concept, it requires Taylor Building Products, I believe, is the Supreme Court case that says that you have to have a party to say that an arbitration provision is unenforceable. You have to have procedural and substantive unconscionability. On the procedural unconscionability, there's not one fact other than the agreement itself that there was procedural unconscionability.
Would you agree with me the trial court did not rule? That the magistrate did, but the trial court judged on the objections did not specifically rule on objections.
The trial court order, and again, that's the only order that you should be looking at today, said that it didn't need to look at substantive or procedural unconscionability because it looked within the 4 corners of the contract and said that whatever the appellants asked the court to do would have broadened the agreement that the parties had made. And parties can only go to arbitration when they agreed to do so. And she was not unwilling, or the court was unwilling, to make an agreement for the parties that the parties didn't have. And that was to take everything to arbitration because Leaffilter.
And I appreciate that the judge's ruling, and it seems to me that was just based on the language of the contract, but she never addressed their argument of this was unconscionable. This contract is unconscionable. Yes, you're right, that's the language. If we agree with the trial court, she correctly interpreted the language, But don't you still have to decide whether that contract itself is unconscionable?
It doesn't matter. Why do you have to decide things that don't matter?
Why does it not matter?
And why doesn't it matter? Because even if it was substantively unconscionable, and even if it were procedurally unconscionable, it didn't matter. The court was unwilling to sever that sentence to make an agreement that the parties did not make.
But counsel, I guess I'm missing the point, and pardon me, Judge Stevenson, but I guess my whole question, and I think Judge Stevenson was leading up to this, maybe not, but the question is, but if the court determines that that's unconscionable, it just doesn't have to be, striking one line. You could determine that the whole contract for arbitration is void, that the whole agreement's unconscionable, if you have substantive and procedural. So I don't understand why you keep saying it doesn't matter.
Well, I would say, as to that, it doesn't matter because it doesn't matter because the court said that it wasn't looking at conscionability, it was unwilling to make a party arbitrate a case that never agreed to arbitrate. And it wasn't willing to do that.
And is the foundational question with that whether or not there is conscionability to begin with?
If I would argue, and the trial court didn't get to this, but I would argue that the contract itself, and let me just...
You have 2 minutes left. You're looking at time. You have 2 minutes left in your...
Yes, thank you. Even if it were both substantively and procedurally unconscionable, then you are right, the court would have to deal with it in a way. And if you looked at the whole agreement, and the trial court did a good job in saying where the ability to go to court was infused in that contract. But Section 17 says that that it was a mutually drafted agreement. And lastly, Section 12 dealt with severability. It says that in the event that any provisions of this agreement are determined to be illegal or unenforceable, such determination shall not affect the validity or enforceability of the remaining provisions hereof, all of which will remain in full force and effect. It could have said any provision or part of provision. And taking out the last section of a sentence is not taking out a provision. It's taking out a part of a provision, taking out the part of the arbitration provision. And so, if Judge Carr, if the trial court had found it unconscionable, the court should have taken the arbitration provision and struck it. And the parties would be left to going to court, which that's where they wound up in the first place, so it didn't really matter. So
about 30 seconds left. You're answering the question there, so thank you.
I'll donate my time.
All right, thank you very much. About 2.5 minutes left for rebuttal.
Thank you, Your Honor. Just a few points to raise on rebuttal. First, it is wrong for Leaffilter to state that the Ignacio decision excised the whole provision. In fact, it just excised part of a sentence, just like we're asking the court to do here. Now, moving on to the argument that I hear Leaffilter making of, well, it's the parties' agreement. But that glosses over the other point here, which is procedural unconscionability. This, I don't think anyone disputes, was a contract of adhesion. So while Leaffilter can sit there and say the agreement includes a term that says it was mutually agreed to by the parties, et cetera, that just wasn't the case. This was imposed on Mr. Dunphy as a condition of employment. He had no opportunity to change the terms. So again, when it's talking about, well, is severing, changing the character of the parties' agreement, this agreement was, because of that unconscionability, illusory. Now, Judge Carr, I think that you were correct in identifying a key issue here, which is the outstanding breadth of this clause, which is not just for preliminary or temporary injunctive relief in aid of arbitration. We see that commonly, in fact, just last month I went into court and obtained a TRO in aid of arbitration, filed the arbitration demand as well, and now we're off to arbitration. We preserve the status quo. This goes far broader. It includes not just claims for injunctive relief to preserve the status quo in aid of arbitration, but anything else, so long as you have a claim for equitable relief, and we view that as wrong. And then finally, I would like to conclude by focusing on the concept of severability, because the argument that I hear from Leaffilter is basically things are severable when we want them to be and how we want them to be as it suits us, right? Well, it can't be severable to excise a clause in a provision, this unilateral discretionary exception. But if we were to proceed to severability, the severability clause would allow us to sever just the arbitration provision. But that doesn't consider, and I think again, Judge Carr hit on this point, well, it's possible that the entire agreement should be voided, including the provisions on non-competition and the like, if this agreement or this unilateral discretionary exception is unconscionable, which we do believe it was the result of great overreach. And with that,
your time is up.
I conclude my time. Thank you.
Very good. The court will take a matter under advisement and issue a decision in due course. The court will mail a copy of that decision to you upon its release, and also be available on the High Supreme Court's website. With that, I'd like to thank both of you on behalf of the court for your presentation today.